Okay, so this is Chapter 3, NCSE 262, Technology, Ethics in a Global Society. Chapter 3 focuses on the idea of privacy. So, there are three main questions or objectives we're going to go over in this chapter. And like previous chapters, we will talk about examples that in this case, of course, are related to privacy. So the first big question is, what is privacy? We'll see as we talk about that there are different definitions of privacy, and some of these definitions conflict with one another and make it a little harder to pin down a clear, concise definition of privacy. Second, we'll look at how personal privacy is interpreted and how it's protected by law. We'll take a look at what exists in the U.S. Constitution and the amendments to the Constitution that are related to privacy. And third, we'll look at how technology is affecting privacy, and we'll do these things in a variety of orders. As we've done before, we'll look at a variety of test cases. Some of these are real test cases that have happened in the last few years, and some, like before, are ideas that are posed in our textbook. So, you know from interacting with devices and from your day-to-day living that there are a lot of different ways that information can become public rather than private. So, for example, something as simple as a rewards or a loyalty program, such as a card, a shopper's card that you use at a local grocery store. Besides giving you discounts on items, those kinds of devices or those cards are keeping track of information about your shopping habits. And then the grocery store can in turn target coupons towards you that are based on what they think are particular buying needs. So some other examples are body scanners, digital video recorders, automobile black boxes, RFIDs, enhanced 9/11 services, implanted chips, cookies, and spywares. The whole point here is that this is alive and well now, and is only going to continue to become, I wouldn't use the word invasive, that might sound a little too strong, but pervasive is probably a better word to use. So, you know, insurance companies will give discounts to drivers if you agree to install a device in your car that tracks your driving habits. And then it sends that information back to the insurance company. So there are a lot of different things that affect the kind of information that normally we might think of as private, now are suddenly becoming information that can be consumed by many other people. So let's take a look at something. I'll show you an example here in our web browser. The Google Chrome web browser, for example, encourages me to log in when I use it. So I'm going to I'll go ahead and just pop out here for a second to my Google. I'm already logged in, and I'm just going to fast track this. If you haven't done so, I really strongly encourage you to go out to this page. You can get to it in a number of ways. So I'm logged in here, and I better get out of here because that's kind of private. But anyway, here is the information. You go to my account, and explore. Google keeps track of all of your activity. Now you can do some things to control that, but in the most part, it knows my search history, it knows my activity, it knows what I've watched, it knows what I'm searching for. So there's just many things that you should understand here. And this is just one piece. There are many apps that are doing similar things. So as you contemplate that, you need to think about this from a technology perspective, how this is affecting your privacy. Okay, so let's move on. Here's another example. This is a relatively new device called the Amazon Echo, which I'm sure many of you have already heard of. This device is always on and always listening, which I find a little disconcerting, but to each, everybody has their own opinion. So Amazon Echo terms of use ask users to agree to give up some privacy in return for some convenience. So often we are willing to give up some privacy in return for something else. But what about times when we give up privacy unknowingly? And what exactly do we mean by privacy? So I'd like to stop now so that you can read this article, How Target Figured Out a Teen Girl Was Pregnant Before Her Father Died. If you haven't done so, stop and read this article. Okay, so I'm going to assume that you paused and now we're back. So it turns out when you shop at Target, Target collects information about your purchases. This is not unique to Target. Many places also do the same level of tracking of your information. But in this case, Target wanted to figure out a way to advertise to mothers of newborn children. So what they did was they started looking at the shopping trends of women who were pregnant to determine what kind of things that they're buying, and that then they would be able to target to expectant mothers. So, for example, they found that unscented lotions were being purchased by expectant mothers in their second trimester. So they decided to use this information, as I was saying, to send advertisement to mothers, to these expectant mothers. Well, what happened was it went to this teen girl's home. They got Target sent her some coupons for some of these targeted items, and her father saw that and was just furious. Of course, her father didn't know at this point that she's pregnant, but he goes to Target and is just furious. Like, why would you be sending my teen daughter things about pregnancy products? And he kind of blew up. Well, soon thereafter, of course, he finds out his daughter is in fact pregnant, and kind of was able to realize that he was out of line for being so angry. So he went back and apologized. Okay, so moving on. So let's look at some aspects of privacy. First, we are going to start with just a little background on networks and network privacy. And we are talking first about wired networks, and then we'll also talk about wireless networks. We'll then move on to a discussion of a lawsuit that was filed against Google several years ago, and the status of that case now. So first, just to give you an understanding, regardless of whether we use a wired network or a wireless network, when we send information from our computer to a computer anywhere else, the information that we send has to hop from computer to routers, to switches, to other switches and routers, until it eventually makes its way from point A to point B. And if you're interested, you can see this for yourself. In a Windows environment, you would have to go to a command prompt window, type in trace routes. In the Mac, you go into the network utilities, and it's right there. I don't think I need to show you. It's just the concept of understanding that there are multiple stops between point A and point B. So the utility can show me a list of computers that my data will pass through. The fact is that data makes many stops to get from point A to point B, like I just mentioned. And whoever owns the equipment has the data. Sometimes this data is encrypted, for example. So when we're buying something online, most times, and I think this is kind of old news at this point, you always look to make sure that the site is secured before you ever do any kind of financial transactions. But in most cases now, everybody realizes that kind of traffic has to be encrypted. So, but the point is, your internet service provider can collect and store all kinds of data, as well as those other switches and routers in between. So what about Wi-Fi? When you use a public Wi-Fi hotspot, all the data that you send before it reaches actual hardware kind of floats through the air. Kind of a funny visual if you can imagine. But it turns out that there are a lot of network analysis tools, like Wireshark, for example, is one of them, that allow total strangers to capture all the data that is in the air. You know, and there is not anything you can do about it except not do it on public Wi-Fi. So it's one of the reasons that you need to be particularly careful when you're using a public Wi-Fi hotspot. So what about your own home Wi-Fi network? Do you use any kind of security on your home Wi-Fi network, or do you leave it completely open? And if you don't use security, what do you think? Are you okay if a total stranger connects to your data and collects information about your network? Okay, so let's talk about Google because Google had a Street View lawsuit several years back. And basically, if you're not familiar with Street View, I'll just hop out here, and you should be. I think that's it. This is Street View of Miami University, so this should look pretty familiar at this point. This is just High Street, the Honors. Let's see if we can find Benton. So you can kind of see that this is a satellite view, which is what Street View is, and it's real time, and it shows, there's Benton right there, cars. Surprised that it doesn't have any snow there. We've got a lot of snow here in Columbus today, so at any rate, the point of the Street View allows us to put ourselves on the level and actually look around and see what's going on. Google Map does certain things to try and protect privacy of people. So, you know, if I drilled down, for example, and got close enough to one of the cars, used to be that they didn't do this, but you could see the license plate number, and so people started to get kind of funny about that, which caused the lawsuit. But now, of course, if you were to do that, you would see that Google blurs that stuff out. So why was Google sued over Street View? Well, let me get back to my presentation. Well, it turns out that in addition to taking photos, and the way they took photos is with cameras that are mounted on tops of cars. In addition to taking these photos, it turns out that they were also collecting information about all the Wi-Fi networks in the neighborhood where it traveled. Now, what they claim is, if you read different parts of these articles, was that they claim is that they were just trying to get the names of the networks, and that was about it. But it turns out they were also collecting emails and any other free data that was floating around the air. And so they were hit with a $7 million fine for snooping this wireless data. Now for Google, this was not a huge fine, as Google makes over $7 million in an hour. And based on its projected revenue of $61 billion this year, that's really not a big hit for them. So Google was hit with this fine. What do you think happened? Well, what happened was Google took the Wi-Fi snooping case to the Supreme Court. This was back in 2014. And the Supreme Court declined to hear Google's request in the Street View lawsuit. The lawsuit talks about Google wiretapping laws. So is it legal to snoop this type of traffic? In other words, if you download, let's say Wireshark, which is the network analysis tool we were talking about a moment ago, is it legal for you to sit at a coffee shop and snoop the traffic? Well, we can look as far back as the Federal Wiretap Act of 1968. The Federal Wiretap Act was a setup to regulate the collection of actual content of wire and electronic communications. It was passed as the Title III of the Omnibus Crime Control and Safe Street Act of 1968 and is generally known as Title III. The main idea was that it prohibits the intentional interception, use, or disclosure of wire and electronic communication unless there is a statutory exception that applies. So in general, these prohibitions bar third parties, including the government, from wiretapping telephone and installing electronic sniffers that read internet traffic. Now consider the fact that this was written in 1968, and so the electronic sniffers that read internet traffic was not actually part of the original Wiretap Act because they weren't around then. This is an article about the Act and the interpretations of that. So is it legal? Is it okay or not okay to sniff and capture Wi-Fi traffic? Should or does it apply to Wi-Fi? In 2010, the Google Street View lawsuit, Google was sued for doing just that. In 2012, in Illinois, a federal judge ruled that Wi-Fi sniffing does not count as wiretapping. But if you look at more recent information, it seems to be almost unanimous now that Wi-Fi sniffing is indeed something that would count as wiretapping. I'm going to leave it to you to look at some of these other articles and get a better understanding of where Wi-Fi sniffing fits in the context of that. So in other words, it may not be okay for you to sit in a coffee shop and sniff the data that's in the open air, but it may be. So, okay. I don't know that we'll talk about that, but it may come up, so just kind of look at those articles. Okay, so let's think about this. If two students are sitting in a classroom having a discussion, and you overhear the conversation, have you invaded their privacy? Probably not. Somebody could argue that if someone wants to have a private conversation, they shouldn't sit in a classroom and have that conversation where other people can listen. What if two people are sitting in their house having a conversation and you hide in the bushes outside the window and listen to that conversation? Have you invaded their privacy? Probably, because, we expect privacy in our own home. But what about emails? When you send an email, how much privacy do you think you have? Is it the privacy of a conversation in public? Is it the privacy of a conversation in your home? Remember, email is sent over networks and can easily be read, wired or wireless. So does this mean that email should be treated like a public conversation? Is it okay for a professor to give the assignment of capturing emails that are sent wirelessly? Good kind of question to contemplate, but we'll leave that for now. Okay. Ed Snowden. Many of you probably are familiar with who he is. Ed was working at the NSA, which is the National Security Association, part of the government. Said he was upset to find out some of the ways that NSA was doing surveillance. He left the United States, released information he gathered about the techniques. What kind of things did he reveal? Take a look at the articles in this slide to review this. version on a daily basis provides the NSA information on telephone calls within the U.S. and between the U.S. and other countries. The NSA gathers records of online sexual activity and visits to porn sites in an effort to discredit the reputation of those believed to be jihadist radicalizers. The NSA is backing 5 million records a day that monitor the location of cell phones around the world. In a scale, scope, and potential impact on privacy, the efforts to collect and analyze location data may be unsurpassed among the NSA surveillance programs. The NSA uses Google-acquired cookies relied upon by the internet advertisers to track preferences on consumers. And perhaps most interesting, by a computer science perspective, is the NSA paid the RSA, which is a large computer security firm, $10 million to build and promote a flawed encryption system that left open a backdoor through which the agency intelligence could enter. So, again, we're highlighting how technology is impacting our privacy and how it's currently being used. It's a little, I don't know, scary, but certainly worth contemplating as a consumer. Just, you should be aware. Okay. So, the privacy issues can become complicated. So, there's a story where Michael wrote an essay, which is case 3.2 in your textbook. What began as Michael completing an assignment for a class ended with his essay appearing on blogs, getting TV and newspaper coverage, and him getting harassed and threatened. To what extent was Michael's privacy violated, and who violated it? So be familiar with this case and be prepared to discuss it in our online session for this chapter. I'm not going to go into the whole thing because I'm assuming you've read the article, but and if you haven't, you need to before our class because it will come up. So the question is to what extent was Michael's privacy violated and who violated it? And is it unethical for professors to use plagiarism preventers without student consent is another question. And is it unethical for plagiarism preventer to give the full text of a student's work? So that kind of should give you an idea if you haven't read the story about what's going on. Okay, so let's get back to the question of what exactly is privacy. We'll look at three definitions that are different definitions. Because these definitions are different, it can make it hard and complex to come up with a precise definition of privacy. We will look at each. Sometimes the definitions compete. It can make it difficult to define. It can make it difficult to define privacy precisely. Note that the Constitution does not guarantee a right to privacy either. So this first definition of privacy is the right to be let alone. This is a conception of privacy that focuses on the grievance felt by the harmed party and on actions that directly make them feel harassed, embarrassed, or exposed. So if someone posts a video of you on YouTube and it embarrasses you, you might feel that your privacy has been violated. But it may be perfectly legal for that video to be posted, depending on where it was filmed. We do have a right to be let alone when we are in a place where there is a reasonable expectation of privacy. So you wouldn't expect privacy out on the street. You would expect it in your home. And in a commercial establishment, it depends. Okay, Okay, so in 1890, Warren and Brandeis argued the courts were already recognizing people's rights to privacy, and then they were able to pose situations where contract laws and intellectual property rights did not actually protect their privacy, and said therefore that we need to have privacy laws. So as an example, let's take a look at an example that shows that these privacy laws don't actually protect one's privacy. So when someone is talking to a newspaper reporter off the record, there is an implicit contract that the reporter won't share this information. But what if someone is secretly listening in on that conversation? There's no contract for that person listening in. So Warren and Brandeis argued that contract law fails to protect privacy in such situations. The second definition of privacy is concealment, and you should notice that this is a very different kind of privacy than being let alone. The concern here is the ability to have control of our own information so that it does not become public unless we want it to become public. So in the case of Michael's essay, the professor from the other school, who didn't even know Michael, could be said to be violating Michael's ability to limit his essay to his own professor and himself. So in other words, this kind of privacy is when we want to be able to keep information secret. So Judge Posner wrote an article 2 weeks after the Boston Marathon bombings in April of 2013. He argued against the right to conceal information. You need to read these and watch these videos to get his argument here. But he argued against the right to conceal information. You may sometimes hear someone make the argument, I don't care if the NSA is listening to my phone calls. I've got nothing to hide. But go out and look at this, and for an opposing view, see the second link. The third way we will look at privacy is by looking at Solov's taxonomy. Solov felt like there were too many different types of privacy. Daniel Solov's view of privacy is to stop trying to find an all-encompassing definition. Instead, let's try to list the common privacy problems so that we can begin making policies. Let's take a look at this article. You can find his taxonomy of privacy here in this article that was written in 2006. Privacy is a concept in disarray, and nobody can articulate what it means. As one commenter has observed, privacy suffers from an embarrassment of meanings. Privacy is far too vague a concept to guide adjudications. So in this article, his taxonomy is a list of different types of privacy problems. You should become familiar with these various types and consider the exercise of looking at some of the various cases we've examined and seeing if you can classify the types of privacy issues in this list. This list also appears in your textbook, by the way. So for example, he focuses on the category of information collection, which includes surveillance and interrogation. We're not going to define all of these here, but some of these are obvious in what they mean anyway. So information processing includes aggregation, and no surprise by now to most of us, computers have made it much easier to aggregate data. That is, to take a lot of data that might seem unrelated, but then start connecting the data together in order to form a more complete picture of something. So for example, the target case of using shopping data to target expectant mothers. There's identification, which is taking information and figuring out who that information belongs to. And all of this is happening today, and on levels that I don't think many of us even comprehend. So again, my hope for you in this course is that at a minimum, it causes you to really think, because I think many of us don't care, we don't think about this, but you really should. So there is insecurity, which is not safeguarding collection of personal data against theft. There's a secondary use when which uses data that people willingly give for one purpose or another, but for some other purpose they do not approve. There is an exclusion, which is failing to notify individuals that their data is being collected. So these are just some of the terms, again, you should be familiar with. Then there is this category of information dissemination, which is the sharing of information. Breach of confidentiality is one concept under this category, and hopefully, if you pay attention and you certainly know that breaches of information and confidentiality are happening daily, unfortunately. Probably the last big one was the Equifax, which is the people who do our credit reports. And that was huge, and you know, it's really largely been swept under the rug, which I find kind of atrocious, but that's a different topic, sorry. So the reporter whom we were just discussing broke confidential information that was shared. There are many concepts here that I'm not going to read through, but I expect you to have a solid understanding of all of these. So a challenge for you that you should be prepared to discuss is to take the various privacy examples from these notes and this presentation, and for each of them, try to match issues within the taxonomy to the actual stories that we've read about. And you match them, and the expectation is you need to figure this out, and we're going to talk about it in our online session, okay? So we've looked at 3 different definitions of privacy. The right to be let alone, privacy as concealment, and there's privacy that is broken down into a taxonomy of different types of privacy problems. Now let's take a little look at what the U.S. Constitution actually says about privacy. And as it turns out, it doesn't say very much, which should be concerning, or at least raise your curiosity. The U.S. Constitution is our country's go-to document when it comes to questions of rights and laws, but very few of them have anything to say about privacy. There are 27 amendments. The first 10 are the Bill of Rights. None of them are about the right to privacy. So this is understandable since privacy is kind of difficult to nail down. The First Amendment allows for people to practice their religion. That gives people a certain level of privacy to what religion a person wants to practice. The Third and Fourth Amendments give people a certain degree of privacy in that they protect their home and possessions. So if you read through those. And the Fourth Amendment says that if a home is to be searched, it must be with probable cause and only after a warrant is issued. We might compare that to the NSA surveillance and see how those two fit. I think you might find some contradictions there. The Fifth Amendment says that one's own knowledge can remain private, that a person is allowed to conceal information about herself or himself. The 14th Amendment says under Section 1 that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the U.S., nor shall any state deprive any person of life, liberty, or property without due process of law. The 1969 case of Stanley versus Georgia involved a police raid of a person suspected of running an illegal gambling operation. No evidence was found, obscene movies were found, and Stanley was convicted of obscenity. The Supreme Court overturned this conviction and overturned all state laws that banned possession of obscene materials. So, for example, the Supreme Court supported an Ohio law that criminalized possession of child pornography, and they overturned that. All right. Not probably something you need to know too much, but moving on. When we have a conversation at home, we expect privacy. When we are having the same conversation in a restaurant or a park, we don't expect that privacy. So in some cases, it is easy to define when a person's privacy has been violated and when it has not. But sometimes it can be fuzzy, like a phone call in a public phone booth. Don't even know that those exist anymore, but an email communication. What about someone sitting on the front porch of their house? What about the back porch? What if you really have a really powerful lens on your camera? Technology is changing our ideas of what is reasonable. Satellite imagery can give clearer images than ever. I mean, it's absolutely amazing that you could Google Street View, as we mentioned, captures faces and license plate numbers, but then now blurs them out because it's just that obvious. So the question is are they required to do this? Smartphones with cameras are everywhere. And in fact, Miami University's locker rooms have a cell phone rule to protect the privacy of those using their rooms. So no cameras in the locker rooms, basically. All right, so the Camera Phone Predator Alert Act singles out camera phones instead of addressing all digital cameras and video recording devices. So in short, this is a bill that requires mobile phones containing cameras to make a sound when they take a photograph. Currently, this bill has not been passed yet, but it was set up because Congress found that children and adolescents have been exploited by photographs taken in dressing rooms and in public places with camera phones. So does it make sense that this bill singles out camera phones instead of addressing all digital cameras and video recording devices? Technology is rapidly changing our view of privacy. It is easier than ever to obtain and store data using servers located in other countries, and laws differ from country to country, which only makes this more complex. So suppose a writer from country A posts an article on a server in country B about someone who resides in country C. But then that article is readable only by people in country D. If they all have different laws, then which laws ought to apply and why? These kinds of questions did not come up very often until technology made it possible for us to store information on servers in these different countries so easily. There are a couple of other cases to look at that are mentioned in your book. I'll mention this one last case and then leave one case for you to investigate. So this case is the Lower Merion School District case. And at the heart of the problem is a piece of software called LandRev, which had a theft track feature that was meant to help school administrators track down missing laptops. But it turns out that those cameras, the devices in there, could also record and take images of kids when they didn't realize what the images were being taken. And so the school district sued, and so far the legal case has reached $1 million. And the school had issued 2,300 laptops to the students, so it could be quite a concern. So that's one case. In this last case for you to consider is the Texas Infant DNA Database. You should read about this and be prepared to discuss this case during our online session. Okay? So when we do meet for our online discussion on this chapter, the topics that we're going to discuss can be found here. Michael's essay, case 3.2, has discussion questions at the end of this case, and I'd like you to be prepared to discuss your answers to some of those questions. Solov's taxonomy, in which you're supposed to look at some of the cases here and line those privacy issues up with these cases. You should be prepared to do that. And then finally, this last case, the Texas Infant DNA Database, case 3.8, and the discussion questions at the end of that. And I believe that takes us to the end of this lecture, and I look forward to our online session. Thanks.